May it please the Court, Andrew Craven. I'm here on behalf of Norwegian Cruise Line Bahamas and NCL America, two of the three defendants in the case, in this maritime case that's before the court.
Would you like to reserve some time for rebuttal?
Yes. Of the 10 minutes, I'd like to reserve 3, if I may.
Sure.
May I proceed?
Yes.
We're here because our position is that the trial court erred in allowing the plaintiff to amend her complaint to assert a claim for punitive damages. There were originally 2 issues that were filed in our petition. One related to punitive damages in the context of a claim for unseaworthiness. In response to our petition, the plaintiff respondent here dropped that issue, noting that it was moot. So unless that comes up later, I'll skip over that issue and focus on the issue for today, which is the claim for punitive damages as it relates to the plaintiff's maintenance and cure claim. Very quickly, maintenance and cure is a seaman's right that they're entitled to when they're injured. Maintenance is essentially cash value.
Let me ask you a question.
Sure.
Before we even get there on procedure, Mr. Craven. You're here on a petition for cert, correct?
Correct.
And what is our standard? What do we look at on such a procedure where it's punitive damages involved?
Correct. Under the Florida statute, this court can look at the trial court and is required to look at the trial court to ensure that it followed the procedure set forth in the Florida statute. This court cannot look at the evidence and determine the sufficiency of the evidence. The plaintiff notes that in their response, and we don't take issue with that.
So tell me where the trial court went wrong on procedure.
Sure. So considering the Supreme Court has said that the appellate court can review the procedural aspect, this court, the 3rd DCA in the case of Carnival versus Iscoa, stated that to allow a claim for punitive damages to be pled when punitive damages are not available as a matter of law is tantamount to failing to have an evidentiary hearing, and therefore it does not meet the procedural requirements. So the fact here is that of the 3 defendants, only one can be the claimant's employer. We don't know who that is at that point. That issue hasn't been addressed in the lower court. But the lower court has said all 3 defendants are now potentially liable for punitive damages by allowing the amendment. As a matter of law, only one of these defendants can be responsible for punitive damages. And what the 3rd said in the Iscoa case, and to quote it, is that to allow an amendment for punitive damages without determining whether there is an evidentiary basis is a failure of the procedural requirements under 768.72, and further stated that allowing an amendment for punitive damages is tantamount, when they're not available as a matter of law, is tantamount to that failure in the procedural requirements and to allow an amendment.
Gotcha. Okay.
Did that answer your question?
Yes,
so procedurally, we don't take issue with that the court cannot revisit the trial court and test the sufficiency of the evidence. But regardless of the sufficiency of the evidence, when punitive damages would not be recoverable against 2 of these 3 defendants, whoever that may be, they're therefore unavailable as a matter of law.
Well, when will that be determined?
It would be an issue.
It might be determined at trial who the employer is.
Well, actually, the determination of who the employer is, and it's I believe it's the Sofitel Solette case. I apologize. Is an issue of law. One of the cases states that determining who the employer is will be an issue of law, so it'll be fleshed out at the summary judgment stage.
So you're concerned that there's going to be discovery with regard to punitive damages on, for 2 defendants who are not subject as a matter of law
Correct.
to punitive damages before determination that those individuals have no responsibility for punitive damages.
Correct. No matter how it shakes out, 2 of the 3 are not going to be the employer who is responsible for maintenance and cure, and therefore cannot be responsible for punitive damages. But the trial court treated all defendants collectively.
So then, until the court makes a determination as to which defendant is in fact the employer, is your argument, discovery on punitive damages should not be allowed to take place.
Correct. And what the third...
Which was the employer? Do we know?
Our position is the employer's American Guard Services. This plaintiff was a security guard employed by American Guard Services, had a contract with American Guard Services, could be hired and fired by American Guard Services. That company had a contract with the Norwegian Cruise Line, whereby they put their security guards, American Guard Services security guards, on the ships.
Well, are you asking us to You're not asking us to vacate the court's order, it appears to me, and correct me if I'm wrong. What you're really asking us to do is almost an abatement type of thing as to any discovery until the issue you claim needs to be decided is decided.
That may be how it ends up, but what we're asking is that the lower court's order be quashed, because since punitive damages cannot be held against two of these three defendants, whoever that is eventually determined to be, they're logically unavailable as a matter of law as it pertains to those two defendants, which is still
you said that the issue of who the employer is a matter of law, but it's also dependent upon facts. So those facts could be disputed.
Correct. And at the summary judgment stage, there's a
but at summary judgment, you can't resolve any underlying factual disputes.
The case law says it can be the trial court can determine at the summary judgment stage who the employer is.
Well, depending on whether there's a dispute of facts. Let's say if there is a dispute concerning facts, it would seem to me the trial court could not determine any of those facts at the summary judgment stage. That would have to be submitted to a trier of fact, right?
Yes, that would be correct.
Why wasn't the summary judgment done prior?
Summary judgments haven't been heard. There hasn't been a trial date in this case. Discovery was still ongoing. Summary judgment have not been briefed in the lower court. They certainly will be.
Once the summary judgment is entered, finding one party is the employer and the others aren't, could you then come back to us and say, look, drop the punitives as to the others? Or for that matter, go to the trial judge and say, drop the punitives as to the others?
That would be one way to handle it, but I believe under the case law, that it's not really an issue of abatement or waiting until that moment. The case law is clear that as a matter of law, somebody is not responsible. Two of these three are not responsible.
But also as a matter of law, at least one of them is.
Correct.
So where's your irreparable harm if there's no discovery, if discovery is stayed on punitive damages until after that determination is made?
That would be one method for the trial court to handle that and state, okay, no discovery until the summary judgment stage.
But that hasn't occurred. That has not occurred.
Originally, we filed a motion to stay. The court recently lifted the motion to stay.
Stay.
But that's not what's on appeal now.
No, right now what
And
is
then
on...
actually, you're asking for a petition for cert, and I think our remedies are pretty limited. I'm not sure we can abate or whatever. I think we can just quash.
Which brings me back to that point. We do know two of these three defendants...
Yeah, but you're asking us to quash an order which, at least in part, you agree is correct. Because one of them is subject to punitives.
I would not necessarily agree it's correct, because all defendants, and that's part of the issue that's raised, one of the two issues, if I may, that are raised in here. First off, all defendants are treated collectively. Throughout the motion to amend, throughout the proffer, and throughout the trial court's ruling, all three defendants are essentially just referred to as defendants, or collectively referred to together, which is a basis alone for why the lower court's order should be quashed. The second issue which is raised on this, which I haven't touched on yet, is the actual proffer which got us here. What the claimant alleges was done improperly with respect to provision of her maintenance cure, which would theoretically entitle her to punitive damages. And we note if you go through the plaintiff's proffer, there's not one allegation against either of the Norwegian Cruise Line defendants that they failed to pay her maintenance, to give her the cash value of maintenance, or failed to give her cure, some kind of medical care. If you look at the plaintiff's proffer and go through it, again, in some instances, the three defendants are discussed collectively, but in many specific instances, the plaintiff in her proffer says AGS, the other defendant, did not provide me cure on these specific occasions. There is nothing in that proffer that says either of the Norwegian Cruise Line defendants failed to give her maintenance or cure. So,
can we look at that under the standard? I mean, can we look at the proffer?
yes, I would argue certainly you can, because again, although you can't test the sufficiency of the proffer, the court can make sure that the trial court procedurally followed the statute's procedure, which requires a reasonable showing in evidence or in the proffer. Here you have no showing, which I would argue procedurally with no showing, and also no differentiation between the defendants, would be a procedural failure at the trial court level.
We've taken you way over, but we'll let you have a couple of minutes for rebuttal.
Thank you.
Thank you, counsel. Morning.
Good morning. May it please the Court, Your Honor. My name is Richard Rusak for the respondent. This is a writ of certiorari. The Florida Supreme Court, as well as this district, many times has said this is an extraordinary remedy. and the jurisdiction is very limited. It's limited to really answering two questions. One, did the plaintiff file a motion for amend seeking leave to claim punitive damages? The plaintiff did. The second issue is whether the trial court made a finding that the proffered evidence supports the claim for punitive damages. The lower court did. It was a very lengthy hearing. It's 33 pages of a transcript. They made those findings. Now, what the petitioner's trying to do is make these carve-outs to the law, the very restrictive law. The first is, well, Ms. Lagone sued her contract employer and then the cruise lines under the borrowed servant theory, which they can do, and actually their brief says they can do. But what the petitioner is saying is that, well, gee, they want to add another factor in, another procedural element into the statute that's not there, that the court must make a factual determination of who, in fact, is the employer for maintenance and cure purposes. Judge Lowe's hit it on the head. The summary judgment, the facts have to be clusterized. Yeah, a court can find who the employer is if there's no disputed fact, but there is a very disputed fact in this case. AGS is pointing to NCL is pointing to AGS. We're pointing to both. So I don't see a summary judgment, getting around this. And not only that, this is a petition for certiorari. You can quash or not.
Well, based on the facts, isn't who is the actual employer a legal question? The facts are the facts. The woman went to work, so, the facts are going to be out about who she got paid by, where she went to work, who controlled her life in doing it, and the trial judge is going to look at those facts and say, well, as a matter of law, you were employed by here.
Oh, I respectfully disagree, Judge Wells. The facts have to be very crystallized, and it's actually what the...
So you're going to ask the jury to decide who the employer was in this case, and that will be a jury issue in the case, is who she was employed by.
Yes. There's the case cited in the brief for the borrowed servant doctrine. There's 8 factors that the trier of fact or the court has to look at, and they're weighed differently. I don't see how a judge can weigh different factors on a summary judgment standard. That's for a jury. That's a question of fact. And each ones are not given each equal weight. It's not, add up 5 here and 6 here. It all depends.
So when you have multiple defendants in a question like this, you just lump them all together and say we're entitled to assert a punitive damage claim.
Correct.
Against everybody, even though some of them may turn out to be totally exempt from any liability.
Correct.
The jury straightens that all out.
Correct, as long as the plaintiff, which he did, follow statute 76872, filed a motion to move, proffered evidence, and the judge, bases its ruling on the proffered evidence.
Would you agree that at the end of the day, there can be only one employer and therefore only one defendant subject to punitives?
Yes, that is the way that the case law says. There's going to be one, but also the case law says a plaintiff, an injured seaman, doesn't have to choose one, because if they choose the wrong one, it's at their peril. They lose. So the Fifth Circuit, the Federal Circuit, hears a lot of these maintenance and cure cases say, well, there's borrowed servant doctrine. You can sue the different ones, and then it's for the trier of fact to figure out who it is.
If in fact this could be determined, if it could be determined at summary judgment, then isn't there an argument that 2 of the 3 of these employers are suffering irreparable harm by having to go through financial discovery and all of these things that may be privileged, trade secret, et cetera, and then by law they're not responsible? So shouldn't that wait?
Judge, no, and this is the reason why, because we filed this case about, it's a 2012 case. Mm-hmm. We're coming on 2016. A summary judgment hasn't been filed. Mm-hmm. We can't hold up our case until the petitioner files a summary judgment.
Counsel, in the realm of mortgage foreclosure cases, that's like right up immediate compared to the actions we have before us.
But we're dealing with a hurt person, Your Honor, yeah. and we'd like to get this case resolved. If the court quashes on this, which I don't think it can under the law.
But you could file a motion for summary judgment. You could file a motion for summary judgment on it, couldn't you? Or could you? I guess not. Yeah. I guess not. Because your argument is there's an issue of fact, therefore there's no summary judgment.
Correct.
I got you.
The difficulty, I think, is we are not permitted to look at the basis for the granting, and this looks like it's about as thin as it could be on on punitive damages. It doesn't look like there's really much grounds at all. So now you may have 2 of 3 entities that are going to have to disclose all of their finances in a case where punitive damages is so iffy looking that it's it's, debatable whether there should be any claim for summary, but that's not something we can cross. I mean, you got the judge to say, yes, you can make a claim for punitives, and so here we are.
And thank you, Judge
So
Wells.
that makes that even more difficult to realize that there might be two entities here that are giving up a lot of information when, legally, they might not even be obligated to do so.
Okay, Judge Wells, and I thank you for that, because I got some insight of what you're thinking, and if I can address that. First, I do disagree that it's very thin, and this is the reason why.
Of course you do. That's why you moved forward, and that's why you got it. You believe in it, and the judge obviously believed you were correct in that.
And I don't know if I want to take any of the court's time in explaining why, but
You don't need to.
Okay.
It's not.
Yeah,
And then
but let me
second,
say
Judge-
this, I suppose with the trial judge's order, it will now be, it puts some, it gives some motivation for the defendants to go ahead and move for summary judgment. In other words, if, you can get summary judgment heard relatively fast. And if it's a straightforward summary judgment, you can get that resolved, and then I imagine you could, stop the punitives on the non-employers. But there does seem to be a problem that, the defense can play a shell game, and not intentionally, but, where each of the defense are saying, hey, we're not the employer, don't take any discovery in this issue on us until it's absolutely finally determined that the employer, but by the way, you can't determine that at summary judgment because I'm not the employer, and all three of them are saying that. In other words, I would imagine, there's the possibility out there that each of the defendants will resist summary judgment, and the only way to resist summary judgment, one way to resist summary judgment is to say that there are facts in dispute. So that kind of puts the plaintiff in an impossible situation, because they can't get discovery until a factual issue is resolved, but the factual issues won't be resolved until trial, so they can't get discovery. Whereas if the defendants would tee up the summary judgment and get it resolved simply, if it can be, then the defendants can take care of the problem. But maybe you can address that when you stand up, but what do you think of that? That's supposed to be, that should be a question, anyway.
And I think that might be a way to solve the conundrum. It might be the best way is to not deny the petition, put the onus on the defendants to go ahead and vigorously move for summary judgment. A lot of the fact witnesses were taken. The corporate reps were taken. The plaintiff was taken. These issues.
If the facts aren't in dispute, they can get a summary judgment.
If they're not, I claim that they are. But that's for another day.
But if the facts aren't in dispute and we deny the motion to quash, and it goes back down and facts aren't in dispute and they're filing a motion for summary judgment, you're going to move forward with discovery on punitive damages before the summary judgment is heard. Am I correct?
That's correct,
On
Judge.
all three.
I have to. I have to prosecute.
Why?
Why? Because I have to prosecute my case. I can't because
Can't you prosecute your case on the legal issue of I'm giving you a hypothetical that I have no power over, so it really doesn't matter. I was just sitting here thinking about it, and I was thinking that even if it goes back down, even if the summary judgment is set by the court, this is going to be a pretty lengthy summary judgment hearing, I can see by the amount of work that's already gone into this case. So nothing is to stop you from going ahead and taking your discovery, and then if the judge determines that only one of the entities is in fact the employer, then the other two have suffered irreparable harm.
Okay, here's a way, and I don't think this is the vehicle right now to do this.
And it's not my authority to tell you which way to do it or not. I was just thinking out loud.
And I understand that, Judge Schwartz. Suarez, excuse me.
He's shorter than I am,
Yeah.
the other is Judge Schwartz.
I apologize for that.
That's okay.
We're going to have a trial order. I have to do certain things in certain time.
Sure, I understand.
I have to ask my thing. Maybe it's coming upon the defense at that time to move to stay until.
Counsel, you don't even have to explain it to me because it can't enter into my decision on this. We're looking strictly at the petition for cert. I was just thinking out loud.
Yeah.
And I was a trial lawyer for 22 years, so I understand where you're coming from. Okay?
Okay.
Anything else?
And that's it, Your Honor. And just a final thought is that, this court on cruise line cases twice, Judge Wells was a member of the panel on two of the cases, the Carnival versus Iscoa case, which was cited by counsel, as well as Royal Caribbean versus Edison. It's a case where, the court did have concerns about whether the plaintiff could achieve a final judgment of punitive damages, but they said, well, that's reweighing all we have to do is look at is whether or not the procedure was followed, whether the complaint was amended, and whether the judge based its finding on proffered evidence, and that's the end of the discussion. I respectfully submit that the court denied the petition. Thank you.
Thank you very much, counsel.
To address, I think, the major issue that's still out there is the summary judgment stage, and I think I miscited this earlier. The respondent in her response brief cited In re Weeks Marine, Inc., which is the case that stands for determination of borrowed servant, who the employer is a question of law. The court held that the question of whether a worker has become a borrowed servant is a question of law for the district court to determine. That's a Fifth Circuit case, and it cites several other Fifth Circuit cases. And does note, however, the analysis used to determine that question is fact-driven. So the Fifth has said when it comes to the borrowed servant doctrine, although it is very fact-driven, it is a question of law. Therefore, it would be something that is resolved at the summary judgment stage.
So your client can ask the trial judge to resolve that issue of law?
And we certainly would.
But you haven't?
We have not. And part of that also, you've asked the kind of the timing of this case and what's been going on. We actually have a motion to dismiss the most recent amended complaint still pending. The parties have been trying to set it for hearing. I believe our hearing date is in February. It is taking some time. We have certainly, the claimant, and both parties have advanced the case in terms of discovery. Discovery is not closed, and I don't even know if considering I would want to file one summary judgment to have everything heard at one time, this wouldn't be the only issue that would be raised. But it certainly will be raised. It certainly will be resolved, since it is a question of law for the lower court to decide. And once the court makes that decision, it can't be disputed at this stage that two of the three, whoever they may be, two of the three defendants will not be the employer who is responsible for maintenance and cure, and therefore cannot be responsible for punitive damages. That, I think, is the reason for the other case I always cited, if your honors are familiar. It's a lot of it was shareholder derivative actions. Mm-hmm. For some reason, that seems to be a lot of the cases where the appellate court quashed, stating they're not available as a matter of law, so the order is quashed because of those procedural failings.
Thank you, counsel. Thank you both very much.